Your Honor, we're here on a motion to quash on a case based on a June 9, 2019 incident where my client fell on the property owned by the defendant. The defense has issued two sets of DWQs that are in question. The first set is attached as Exhibit A to the motion to quash, and that whole set deals with medical providers. Most of those providers relate to a February 2019 case, which obviously is just a few months before ours. I get that. But there's also requests in there for Baylor Scott and White Medical Center and Medical City Dallas Hospital. And the date range for those records is where we take issue. We object to the disclosure as overly broad, not reasonably limited in time and scope, an impermissible fishing expedition, and irrelevant because they go back to 1991, which is my client's date of birth. So I'm asking for a limitation on the time period on those records. I'm sorry, go ahead.
I was just going to tell you, I handle these pretty much the same on every single case, which is unless there's occasionally head injuries are a little bit different. I don't know what the injuries are, but so 5 years prior, any treatment 5 years prior to the accident made the basis of the suit, and any to the same areas of the body, and any treatment after the accident to the same areas of the body, whether it's related to the accident or not. And that's kind of how I have done that for 14, 15 years. So I don't know if there's something very special about this case that would cause me to handle it differently, but that's kind of how I handle every case.
Okay, Your Honor, I'll only take a sentence or two, but the second set of DWQs go back to insurance files. One is in 2011 and 2013. So again, beyond that 5 years before the incident. And this case, the primary injury that's about 80,000 of the 90,000 in damages is an acute injury. It's an ankle fracture. And you'll see as exhibits D, E, and F, the operative report, the x-ray imaging, the surgical scar that goes up most of the length of the leg. So we're not talking about something that the plaintiff could have walked around with for 10 years or something. This is an injury.
Was there any treatment to any other area of the body or just the ankle?
Primarily, it's just the leg. I mean, the physical therapy, the medication, I would say is probably for soreness and stuff like that too. But as far as real treatment, it's the leg.
Ms. Ryan?
Your Honor, normally we only ask for 3 to 5 years in these, but this situation is a little bit different. This is an injury to plaintiff's leg, as counsel said, and we were provided with medical records by plaintiff that include reference to bilateral foot and ankle problems dating back to this woman's childhood. She's had surgeries on both of her feet as a child, and she's had multiple car wrecks in which she was injured in the last 10 years. Those are dated from 2011, where she went to Medical City for treatment, 2013, where we have a certified crash report, and again in February 2019, where current counsel was her counsel in that lawsuit as well. And we know in that case, she was still treating at the time that she ran through the property during a storm and fell. So I need those records in order to assess the level of her impairment prior to this case, the disabilities she may have previously suffered and had ongoing with regard to her feet and ankles. And it goes to, the pain and suffering claims and the various damages that she's claiming in this case. So this isn't some massive throw the net in the water and see what we can come up with, Your Honor. These requests for insurance records and for medical records are specific to conditions that we know about with this plaintiff. Specific events, specific injuries, specific accidents. The records that we're looking for are not very overly sensitive. We're not looking for psychiatric records or gynecological records, Your Honor. These are going to be with regard to other personal injury cases. So that's why we've asked for further. She's a young woman. That's why we came up with 1991. But I'd be willing to agree to limit it to 10 years back to her accident of 2011.
Response?
Your Honor, she did have these procedures on her legs as a child, but again, if there were lasting or lingering effects, of those surgeries or impairments, we're going to see them if we get records 5 years back. You know, it's not that there's going to be a discontinuation and suddenly it resumes again. I mean, if we are looking at that 5 years before this incident and there's anything ongoing from her childhood or 2011, we're going to catch it in there.
There are specific incidents, though, that continued to happen with the car wreck in 2011, the car wreck in 2013, a car wreck resulting in a lawsuit and ongoing treatment at the time of our accident in 2019. That's not necessarily all going to be
There
captured.
are two different accidents in 2019, or is the 2019 the one that's basis of this suit?
One of each.
Yeah, there's two in 2019. And that's where I was talking about the first set of DWQs, Exhibit A. We actually don't have objection to her securing those providers' records from the date of the incident onwards. Where we have an objection is the request extends to 1991. So if they were limited to, you know, we know that there's this incident and onwards, that's something that we won't take issue with at all.
So what I would say is that the 2013 accident, I guess there was a 2013 accident, that you could request those, have them go to the plaintiff's attorney's office. If there's any treatment to the same areas of the body within, because there could be with 2013 to 2019, definitely could be, you would need to produce those. And then if there's an issue, you can provide an in-camera, you know, request for in-camera inspection. You know, from the stuff prior, you know, her childhood, you know, basically we're just looking for treatment during the 5 years prior, but sometimes it's hard to kind of winnow that out. And so I would suggest that what we usually do in these situations is that you, the records go to, for the records that might be controversial, they go to the plaintiff's attorney. The plaintiff's attorney reviews them, turns them over to the defense attorney. There's an issue. Then we do an in-camera inspection. Does that make sense?
May I ask for clarification on one thing, Your Honor? Because you said that was going to be limited to the same body parts at issue.
Mm-hmm.
One of the things we were looking for, though, Your Honor, is that her prior complaints of back and neck injuries would have created limitations and disabilities for this woman that predate our accident. And so I'm asking that it not be limited to the body part.
What type of lost wage claim are you making in this case?
Your Honor, wages actually aren't an issue in this case. There was an accommodation made by the employer for her to work from home because there were issues with stairs, getting in and out of car, being able to drive. But, you know, I understand what she's saying, that there's impairment here, but it's impairment so directly related to the leg that I don't know what a 2011, you know, claim file is going to really have to do with it. Again, I'm happy to turn over the February 2019 accident documentation. I mean, I have the file. She doesn't even need a DWQ for it.
What about the 2013 one?
The 2013, I don't have.
Are you making a claim in this case of a permanent physical impairment, or are you just making a claim that physical impairment related to the surgeries and the treatment from this accident?
It's still ongoing to this date as far as her foot. She still has areas of lack of sensitivity and things like that on the foot.
But it's just related to the foot?
Just related to the leg.
Yeah, it's going to be related to the same. Then it'll just be this area of the body then. So anything else, guys? Can you get me an order on that?
I just want to clarify, Your Honor. So the 2011 file we're going to say is a bit too old, but the 2013 plaintiff will have an opportunity to review, and anything related to the first set of DWQs, which is provider specific, plaintiff will have an opportunity to review and turn over anything related to the same body parts.
And if the defendant has an objection to any of that, then they can request an in-camera inspection.
Okay.
I thought it was anything that's more than 5 years old was the set portion that plaintiff would be have an opportunity to review. Anything within 5 years, the record service turns over. If it's older than 5 years, then they get to look at it first.
I mean, usually what we do if there's a controversy, and I don't know if there's a controversy or not. I mean, it's like, for example, usually post-accident records, those would all be turned over directly to defense attorneys, anything related to the accident. It sounds like you don't have a problem with turning over the 2019 records directly to her.
Correct, Your Honor.
The issue is this 2013 accident. Those would go to the plaintiff's attorney. They would review it. Anything you need to turn over, anything related to the same areas of the body within 5 years of the accident. And if you feel like they haven't done that, then you request an in-camera inspection.
Understood.
Is that all right? Anything else, guys? And I'm sorry, just how I do this in every case. So I try to be as consistent as possible. Sometimes with head injuries, it gets complicated, but all right, guys, anything else?
That's all.
Appreciate it, Judge. Predictability.
All right, you guys be safe, okay? I'm sorry, I didn't mean to interrupt you.
You're fine. No, it really helps if the judge tells us, this is kind of the standard to expect,
Yeah.
So I do appreciate that.
All right, great to see you guys.